join. Welcome. For those of you who don't know me, my name is Alyssa Hunt, and I'm the Program Director at the Alice Paul Institute. And it is my pleasure to host all of you this evening for our program about the Supreme Court, which is, I know, kind of new territory for us. So in some regards, not in others, but to get started, I want to say that even though we are not gathered together at Paulsdale tonight, for those of you who, like me, are here in South Jersey, the land upon which we gather is part of the traditional territory of the Lenni Lenape people called Lenapehoking. The Lenape people lived in harmony with one another upon this territory for thousands of years. During the colonial era and early federal period, many were removed west and north, but some also remain among the continuing historical tribal communities of the region. The Nanticoke Lenni Lenape tribal nation, the Ramapo Lenape Nation, the Powhatan Lenape Nation, the Nanticoke of Millsboro, Delaware, and the Lenape of Cheswold, Delaware. We acknowledge the Lenni Lenape as the original people of this land and their continuing relationship with their territory. In our acknowledgement of the continued presence of Lenape people in their homeland, we affirm the aspiration of the great Lenape chief Tamanin that there be harmony between the indigenous people of this land and the descendants of the immigrants to this land, as long as the rivers and creeks flow and the sun, moon, and stars shine. And that was taken language directly from the Tribal Council's recommended language. And for those of you who are regional, I would encourage you to go and meet some Lenape community members and learn more about them at their annual powwow that they'll be hosting again in June after a few years of hiatus because of COVID. Moving forward, I want to share with you our program code of conduct. We are grateful to all of you for joining us today, and we invite you to share your questions in the Q&A box during the program tonight. Additional feedback can be shared with us via the response form that we email to all registrants after each program. We are dedicated to making all our spaces, virtual and otherwise, safe and inclusive for everyone. Harassment of any kind will not be tolerated in verbal or written comments during API programs. If anyone chooses to engage in racist, sexist, trans, or homophobic speech or any other kind of harassment or bullying behavior, they will be removed from the program without further warning. Thank you for being a part of our community and for partnering with us to make sure we remain dedicated to equality for all, in word and in deed. So moving right along, I am going to introduce our guests for the evening. Ian Drake, who is here with us, obtained his PhD in American history from the University of Maryland at College Park and his law degree from the University of Richmond. He is an associate professor in the Political Science and Law Department at Montclair State University. His teaching interests include the American judiciary and legal system, the U.S. Supreme Court and constitutional history, and political theory. His recent research interests include the history of animal protection laws, First Amendment rights, and the politics of the treatment of animals used in industrial agriculture and scientific research. Prior to entering academia, he practiced law in the areas of insurance and tort law. Alison Lefkovitz is an associate professor in the Federated History Department at the New Jersey Institute of Technology and Rutgers-Newark. Her book, Strange Bedfellows, Marriage in the Age of Women's Liberation, came out with University of Pennsylvania Press in 2018. Her work also appears in the Law and History Review, the Journal of the History of Sexuality, and the Newark Star Ledger and the Washington Post. So thank you so much for being with us this evening. We're going to go ahead and jump right in. So again, welcome to all of our guests to our program, Judicial Preview, about the Supreme Court and the docket and the upcoming decisions that we're looking for, as well as some that have been passed down since we started discussing this program. So to get started, I think that for a lot of us, kind of at the heart of our interest in the Supreme Court right now is the Dobbs v. Jackson case. So though we are going to discuss some other things this evening as well. So Alison, can you please explain in brief what that is and the questions at the heart of the discussion around this case?
Yeah, absolutely. First, just thank you to the Alice Paul Institute and Alyssa in particular and Ian for joining me in talking to you guys today, but especially to the guests. I'm really excited to have this conversation with you guys. So Dobbs is definitely, I think, one of the most pressing questions before the Supreme Court right now. And This is regarding a Mississippi state law that bars abortion at 15 weeks. So I think the most relevant thing here is that this law is a direct challenge to Roe v. Wade, which puts the point of viability much later. And because it is constantly in the news alongside this, I think it's worth distinguishing from the Texas law, SB 8, that has a similar goal perhaps as the Mississippi law, but a different strategy. The Texas law is designed to be a sort of more unique and more like challenging Roe in a different way by allowing private actors to bring civil suit against abortion providers or those who aid abortions before 6 weeks. The citizen who sues can collect at least $10,000, and the Supreme Court has also allowed it to go forward under the shadow docket. So what that essentially means is right now that is the law in Texas. It's abortions before or after 6 weeks are not currently available to Texas citizens. That is, I think, intended as more of a model for other states to follow rather than a direct confrontation of Roe like the Mississippi law that is at the heart of Dobbs. So we have two different legal strategies with probably similar goals of overturning Roe in some form or another, but with very different strategies going forward. So I'm happy to talk about it more, but I promised brief. So
yeah, Ian, do you have anything to add to that before we move on to the next question I have for you?
So in regard to the Texas law, what makes the Texas law so unusual is the method of enforcement. And it's been criticized even by some of the proponents of the law or the proponents of reducing the availability of abortion as being perhaps too clever by half as a design for a law. It would have been, if it were a law that were traditionally enforced by the government, as most laws are, rather than delegating it to private actors, it would have been pretty quickly struck down, and it would fall in line behind the Dobbs case, potentially as a case that might appear before the Supreme Court at some point. But the Dobbs case is really the chief case that we need to think about, I think, when understanding what the possible future of Roe v. Wade and Planned Parenthood versus Casey is, because the Texas case is really just notable because of its enforcement provision. If it had been a normal enforcement law with the government doing it, it probably would have been quickly struck down, and that would have been it. So I think that that's what's notable about it. But go ahead and ask your question.
Well, you anticipated me a little bit there. I was hoping you could talk about precedent. So Roe v. Wade, Casey v. Planned Parenthood, and obviously the 14th Amendment. What do those have to do with Dobbs v. Jackson and with the conversation around the Supreme Court's current decision?
So thumbnail sketch, prior to 1973, abortion had been legal or illegal in varying degrees at the state level. And there was no federal abortion policy. It was essentially each state could create its own rules regarding abortion. And at the time, in 1973, when this case was decided, there had been actually a gradual movement towards more liberalized abortion laws, i.e. some greater availability of it. What that trend would have been beyond 1973 if the Supreme Court had not decided that abortion was a right that was protected under the federal Constitution, we don't know. But in 1973, the court reviews another Texas law that comes to it that restricts availability. And it was really shocking at the time for a lot of lawyers who knew that there was an effort among activist attorneys to try to get abortion protected as a kind of right construed as a privacy right. Now, privacy as a legal term had meant ever since 1965 with the case called Griswold versus Connecticut. There had been a interpretation of privacy as a constitutional right. The parameters of it, however, weren't well understood. And that's because it had essentially been created out of whole cloth when the Griswold case came to the court. And so its boundaries were unknown. It was effectively rewritten and expanded further in other decisions that came after Roe v. Wade, but it was applied specifically to abortion in the Roe case. So in a nutshell, what had happened was Connecticut had restricted the availability of contraception to anybody, and the Planned Parenthood in Connecticut challenged this restriction, and it went up to the U.S. Supreme Court, and the court held that it was a violation of what it called marital privacy. This was a new concept that the court was embracing in this case, and the Connecticut law actually applied to anybody, married or unmarried, and so this notion of marital privacy was new. So in one sense, the court was striking down the law with this new notion of privacy, but in another sense, they were allowing it to be applied to only certain types of people. A case comes along later in 1972 called Eisenstadt versus Baird that will protect unmarried individuals from the restrictions on availability for contraception. This understanding of privacy was, as a functional matter, really kind of a free-flowing zone of liberty. It could be defined in the future by the court. No one was sure what the parameters would be, but at the time, it was not expected that the court would embrace abortion as being included under this right of privacy. What the court did in Griswold was it looked to several different amendments, the 9th Amendment, the 4th, 5th, 3rd, and 1st Amendments, and it said that these create kind of a zone of privacy, this general sense of privacy that there's certain things that the government just can't touch in terms of activities. And subsumed under this zone of privacy would be availability of contraception. And so in 1973, the court actually does not adhere to the Griswold approach, and they look to the due process clause of the 14th Amendment instead, and they argue that what privacy really is a liberty interest. The 14th Amendment has the due process clause, which says no person shall be deprived of life, liberty, or property without due process of law. And so the court took that word liberty and they expanded it to mean more than the 19th century definition at the time that the amendment was ratified, which meant freedom from involuntary confinement, like being put in jail or prison. And it means something more. In this case, it means privacy. And in this case in particular, it meant the ability to have an abortion. There were restrictions that were allowed. Famously, there's the trimester approach. Who knows what would have happened if it takes 10 months to come to term, but it was this convenient 3-3-3 division based on trimesters of pregnancy. In that first trimester, the state has very little ability to regulate. And that second trimester, it's kind of iffy. There's some ability for the state to regulate, but then there's this degree of privacy that allows for access to an abortion. And then that third final trimester, there's more leeway for the individual. And so this trimester system existed ever since Roe, and it was largely reaffirmed in 1992, but the standard for evaluating cases was changed with a case from Pennsylvania called Planned Parenthood versus Casey. And in that case, the court created what's called the undue burden test. And the undue burden test theoretically no longer is guided by the trimester division, but it's merely a question of whether or not what the state wants to do in terms of restrictions presents an undue burden on pregnant women to decide whether they want to end their pregnancy through an abortion or not. And that standard has been the governing standard effectively ever since. How much Casey really changes things is a matter of debate. Obviously, it does not overrule Roe. The availability of abortion is still considered constitutional law. And the Dobbs case is going to test that directly, because the Mississippi statute that's at issue in Dobbs, it's really a question of whether or not that undue burden is going to be considered a strict standard that the court will adhere to. It's notable that only a little over a year and a half ago, in a case called June Medical Services versus Russo, there was a Louisiana law that was struck down by the court that required doctors to have, who perform abortions, to have admitting privileges at a nearby hospital. And in that case, it was a 5-4 case where Chief Justice Roberts relied on the Casey precedent from 1992, holding that the law did impose an undue burden. And in that case, the so-called 4 liberals on the court, Kagan, Sotomayor, Breyer, and the late Ruth Bader Ginsburg, all voted to strike down the law. And so I think it's instructive that we're not entirely certain how the voting will happen in any given case, because Roberts would perhaps not have been an expected vote with the majority striking down that restrictive law. And so a law that effectively opens up a much greater latitude for states under the Dobbs approach, it's not entirely certain how Roberts is going to vote. And believe it or not, I don't think we know enough right now to know exactly how someone like Justice Kavanaugh or even Justice Barrett may vote on this. Although I agree that if anyone listened to the oral arguments in this case, which happened back in early December of last year in the Dobbs case, it would indicate that there is a great deal of skepticism from the conservative-leaning justices on the court. I know that was a long-winded response, so forgive me.
That was great. That was super informative. I actually am going to totally deviate from what we discussed, because I have a question that I think, Alison, you may be able to answer. Since we're talking about precedent and talking about abortion and legality and illegality, the Comstock laws and privacy, and how that bears on the understanding of what viability means, and how, like, where this notion comes up in terms of a legal framework instead of like a private one.
Yeah, that's a great question. Thank you. Yeah, I think when, the general public thinks about abortion and legality, the sort of familiar transition is from being illegal before Roe and then legal after Roe. But I think historians are more familiar with a sort of longer durée, where in the early 19th century, abortion before quickening was legal. So quickening was essentially the term for when women first felt a fetus moving. And obviously this is both pretty subjective, right? A woman could feel a fetus move and not report that, especially at the beginning. And also that depends on a lot of things, like if it's a woman's first child or her 5th, there's sort of a lot of questions there. But essentially, I think the significant thing here is that in the early 19th century, abortion was not illegal, right? It was legally accessible. And we know from some historical records that women did pursue them with midwives. There were many women who were aware of herbs that could help produce abortions and things like that. It's only in the mid 19th century that states began to pass laws that make abortions illegal. And historians sort of argue about what the causes of this were. Some historians argue that it really kind of comes out of a battle between medical doctors and midwives. Medical doctors before this are not as reputable as maybe they would like to be, and they're trying to gain a level of professional dignity and also gain this huge market of childbearing that they currently had ceded to midwives. So it could be a sort of professional battle, but there's also a sense that this is also emerging out of fears about women's changing roles in the family, that women seem to be engaging in the public sphere more than some people would like them to be doing. And also the idea that maybe the wrong in quotes type of women are having too many babies, and the right also in quotes kind of women are having too few. And so some of these restrictions are inspired by this as well. So this is, a state-by-state process. It's starting in the 1840s. It's spreading across, the country essentially. But a big part of this is a larger backlash against the availability of not only birth control, the medicine, but also knowledge of birth control and abortion. So the Comstock laws are passed in 1873. They criminalize the mailing of all obscene materials, including pornography, but also information or equipment for birth control and abortion. The Comstock itself refers to Anthony Comstock, who is a postal agent, but it's really sort of advocated for by this doctor who led the way for the American Medical Association named H.R. Storer. So they're really sort of working in lockstep together, a sort of medical legal coalition to reduce access to not only abortion, but any kinds of birth control and any kind of obscenity as a whole. So I can go more into that as well, especially that for a while it actually doesn't slow down abortion that much. I guess I'll add one quick note that the Michigan Board of Health estimated in 1898 that 1/3 of all the state's pregnancies ended in abortion, and most of these by the middle class and well off. This is definitely before there's like scientific approaches to statistics, and also a difficult statistic to establish even despite that. But it does seem that abortions were pretty widely available even after the Comstock laws. They were covertly advertised in newspapers. And it's really sort of later in this era that they're not only illegal, but increasingly inaccessible. They never go away entirely, but they become harder to find.
Thank you. That I think that context is really important when we have these conversations and think about these questions, because it's hard to adequately, I mean, though that's hard in general, but adequately or accurately assess the moment you're in without having that kind of longer look back. So the question I want to get to is, what's going to happen? What do you think? But Ian pointed out that that's really hard to know. And I know you had some slides that kind of talk a little bit about why and how the Supreme Court works and why it's really hard to predict. So I was hoping you could share those with us now.
Okay, thanks. Give me one moment. Let me share my PowerPoint.
And while he's doing that, just anytime you have a question for our all of our other guests who are here, just go ahead and drop it right in the Q&A, because moving forward, we're going to be definitely hoping this is a conversation. We have questions, but we want to hear what you're thinking and wondering too.
All right. Are you able to see this?
Mm-hmm.
Okay. So this is a chart taken from the website SCOTUS blog, which is the Supreme Court Watchers blog, and it's helpfully color-coded in terms of their political affiliation. The 6 conservatives in red and the 3 liberals in blue. And in regard to what Alyssa was describing, which is my contention that it's not always for certain how the court's going to come out on a decision, I think that this chart is helpful. This comes from the 2020 term. The court accepts cases on a rolling basis throughout the year, but its work is divided into terms, and a new term always starts in the first Monday in October of every year, and it runs until usually around, there's no set end date, but it's usually the end of June, sometimes early July. And this is the totals for, or this is based on data from the 2020 term. So it started October 2020, ended last July in early July in 2021. And so this is the vote totals for the percentages that you see on the far right of the screen for how often each of the justices was in the majority. Now, in one sense, especially with the color coding, you could say, well, this looks like it's a conservative dominated court. The conservatives are in the majority far more often than the liberals, and that is certainly true. However, even for those such as Sotomayor, who are in the majority the least frequently, she is in the majority almost 7 out of 10 times. And that means that everyone else is only a slight gradation above her in terms of being in the majority. And so while I would not argue that this is a moderate court in the sense of political domination by one side versus the other, it's certainly notable that the liberals aren't in the minority 30 or 40% of the time. They're in the majority usually 70% or 3/4 of the time. And this suggests that the court's perhaps not as divided as it is sometimes popularly perceived to be. I'll give you another example. This is the same data represented in a pie chart based on what's called the merits cases. These are the cases where they review the substance and actually come to a decision disposing of the case. And this is, again, all from 2020. And what we see here is, based on the shading of the purple here in the middle, you see that 43% of the cases were decided 9-0 or 8-0. The reason there's an 8-0, even though there are 9 justices on the court, is because Ginsburg's replacement had not been confirmed yet. And so there were several decisions issued without a 9th justice. So 29 cases were decided with no dissent, so it was a unanimous court. 10 cases with only 1 dissent, and 4 with 2 dissenting votes. And so the majority of cases are usually pretty lopsided, where the justices by and large agree with one another. In fact, there was a small minority, and this is pretty typical, where it was a 6-3 or a 5-4. This, of course, being the closest division. And we usually think of these as being the most politically contentious cases. And so I'll give you an example of where you might expect that there would be sharp division based on ideological disposition of the justices. The Dobbs case, of course, is one where we may have that, but a couple of cases that were, ironically enough, I'd prepared them to be included as a discussion point for their value as interesting cases, but these are cases that were decided just today. So the decision came out this morning. And this is one, has nothing to do with abortion rights. This is a Ramirez versus Collier. This was a religious liberty case where this man, Ramirez, was scheduled to die via lethal injection in September of last year. And he had requested that his pastor be allowed to physically touch and audibly pray with him while in the death chamber, while he was being executed. And the state of Texas did not want to allow for this because it thought it would be difficult to manage varying requests that prisoners would have, or people who were slated for execution would have, in regards to what form of religious observation they would be entitled to. And so the question came up to the court, and the court decides in Ramirez's favor. He wins the case 8-1. This is not a death penalty case, I should note. He will eventually be executed under Texas law, but he wins the case in terms of being able to have his religious observation according to his wishes, where his pastor will get to touch and audibly pray with him. Chief Justice Roberts wrote the majority opinion that was published today. The only dissenting vote was Clarence Thomas. And so that's where you've got a unified court on a issue that you might expect to have more divisions in terms of left-right conceptions of religious liberty. Another example is a free speech case that was also decided today. This is the Houston Community College versus Wilson. The man pictured here is the Wilson of the case, and David Wilson had been elected to the Board of Trustees for the community college, and he's kind of a classic gadfly personality. He was accused of doing things like leaking information about some of his fellow members of the commission board, and he engaged in negative robocalls about his fellow trustees in terms of essentially trying to badmouth them to potential voters in an effort to get them off the board. And so he was, there was a vote condemning him or censuring him by the rest of the board, and he challenged this vote as a violation of his First Amendment free speech rights. And it was held by the court that he did not possess any First Amendment claim from the board's, what the court called purely verbal censure. And so he did not have a First Amendment claim, but it was a unanimous decision by the court. And so that's a good example of, cases where you might expect that the justices are going to be sharply divided. And in fact, they have a great deal of unanimity. So in regard to Dobbs, if you paid attention to the back and forth of the oral arguments back in early December, it was argued December 1st of 2021, you would get the feeling that there's a lot of skepticism, especially from the conservative members, about whether or not Mississippi can enact this law and enact these restrictions, and whether Roe v. Wade is still or should be constitutional law. And so I will readily stipulate that this could come down as a 6-3 decision in some fashion overturning Roe v. Wade. I am personally skeptical, though, this will be an outright rejection of Roe v. Wade or abortion as a right of privacy under the Constitution. There may be some allowable restrictions where the state effectively wins, but I would frankly be a bit surprised if this is an outright victory for those who oppose abortion as being legally available at all or a constitutional right at all. It may be something where you see some strange bedfellows in terms of justices who might side with those that they're not perceived to be politically aligned with. So it's possible, for example, Chief Justice Roberts could vote with Breyer, Sotomayor, and Kagan in resisting the state's ability to do this. And the unknowns are, at this point, Kavanaugh especially, because his jurisprudence on abortion rights is not terribly clear, but also even Barrett. I assume very clearly that Barrett is personally against abortion, but there is the possibility that she may be reluctant to simply overturn Roe wholesale. And we can, Alison and I can talk about this perhaps at further length, but that's one point I just want to make, is that, it's not always predictable how the justices are going to come out on some of these seemingly contentious issues.
Yeah, Alison, what are your thoughts there?
Yeah, absolutely. Ian raises some really important points about how, one, that the majority of cases raise technical or even constitutional issues that really aren't as divisive as we would expect them to be, and also that it is always difficult to predict what the Supreme Court will do. I think that this is also, especially if we try to think in exact terms of what the ruling will be. I think one of the criticisms of Roe including from Ruth Bader Ginsburg, was that it was a decision that happened on the federal level before there had been a chance for a lot of states to start to legalize abortion. So a couple states had been moving in that direction. New York, for example, had legal abortion before Roe v. Wade, but that the sort of other models for changing constitutional law usually allowed many more states to make changes on the state level before the Supreme Court sort of joined them. So one of the famous examples is Loving v. Virginia, which overturned miscegenation laws. Many states had overturned their own miscegenation laws before the Supreme Court overturned them entirely. So I do think that there is a definite possibility where the Supreme Court takes a more moderate approach to Dobbs and restricts but does not overturn the constitutional right to abortion. And especially since we do know Roberts is really concerned about the court's reputation right now, I think that he will certainly be one of the more likely justices to join the liberal justices in that. I have my doubts that we will have the same row that we have now, just based on the questioning we heard in December. But, you know, it's difficult to say, and that's part of what's interesting about watching the Supreme Court. And the exact version of what we get, even if it is a more restricted right to abortion, I think it's definitely especially hard to predict. So all great
Could
points.
I say something about what might happen if Roe itself were just simply abolished or
Sure.
overturned altogether? I think what you'll see is a return in some ways to the pre-1973 status quo. In other words, legally, what you would see is if the court decided Roe v. Wade was wrongly decided, there is no constitutional right to privacy in the sense of an abortion right. That would mean legally that all the states are now left to regulate abortion as they wish according to their laws. And what you will likely see, if this were to happen, is states like New York, and New York's a good example of this, where they're going to pass a law that says if Dobbs overturns Roe, the abortion law will be what the law is now under the Roe precedent. And so that state law will be very liberal in regard to abortion access. And then you're going to have conservative states that will restrict it in some fashion. Keep in mind, even Mississippi doesn't outlaw it entirely. It greatly restricts it, but it doesn't entirely abolish it. And so you're going to get this gamut of results from the different states. And it will, as Alison was mentioning earlier with the Ruth Bader Ginsburg comment, she noted that this will be something that's going to be hashed out at the state level. There'll be some states that'll pass constitutional amendments for their own constitutions that will effectively try to put that the right to abortion or a right to life, as the states will frame it, beyond the easy reach of a majority under the state law. And so you'll get a wide variety, I think, of legal statuses for abortion access.
I think some states are already experimenting with this too. I've been really interested to see Missouri, for example. I don't know if anyone's been tracking a proposed bill in Missouri that got a lot of press because it included ectopic pregnancies in this proposed ban, but which, as you know, medically they are not viable and are likely to kill the woman who has an ectopic pregnancy. But there's also a proposal in their bill that Missouri women are barred from leaving the state for abortion. So there's already the anticipation by some states of this like quilt of different abortion laws across the United States, and some attempts to bar that. Now, whether that would hold up in court, whether that'll even pass, you know, all these things are really up in the air right now. And I think it may depend on what happens in the Supreme Court. It may depend on what happens in Missouri local politics. You know, it's hard to predict any of this, but a lot of lawyers are being quite clever right now about their approaches to how to restrict abortion access, essentially.
Would barring someone from leaving the state not be a direct affront to that liberty clause in the 14th Amendment?
I don't think you would be able to successfully bar anyone from leaving a state. The question would be whether you could punish them for an act they've done in another state under your own state's law. There is it's considered a fundamental right of constitutional law to interstate travel. And that type of punishment for extraterritorial acts would, I suspect, be, well, number one, it would be challenged, but I suspect it would also be held unconstitutional for a state to do that.
This actually brings me to another question I had about the Texas law and deputizing private citizens. I think that posses are deputized under sheriffs way more than people realize today. It's still, I mean, I don't know that it's a common practice, but more common than I think people know, because you think about it as like something that happens in Deadwood, but it definitely does still happen. So, but it seems very different to just say a blanket availability for you as an individual to try to prosecute essentially other private citizens or private entities the way the Texas law does. Can you talk about that a little bit?
I think you're still muted, Ian.
Oh, I'm sorry. Can you hear me? Can you hear me now? Okay. Yes. Was that question directed to me or to Alison? I'm sorry.
Oh, so that was just generally to both of you. I can be more specific. Sorry. But I think both of you actually probably have unique perspectives to offer on that I'd love to hear.
Alison, you can go ahead.
Sure. Yeah, I mean, I think that this is part of the goal of the statute was to be clever, really, to evade kind of obvious grounds for overturning it. And, that has been successful. And I think that the other thing that's notable about it is that for women in Texas, the difference between Roe being overturned and having this state law at the moment, there is no difference, right? I guess there's the 6 weeks, but as I didn't realize until I got pregnant, that's maybe 4 weeks of actually knowing you're pregnant at best, because pregnancy dates are like based just on when you last had your period. So you actually may not be even pregnant yet when you are technically pregnant. So it's a pretty narrow window that women in Texas have to get an abortion right now. And, that is different than having lost a constitutional right outright to some degree, but maybe less so in practice. So I guess that's my initial thought. And then the only other thing I'll say is that Ian totally rightfully mentioned that there are some critics of this, in part because, people sympathetic to that cause are worried about how this innovation might be used in other ways. California Governor Gavin Newsom immediately threatened to use this for gun control, and hasn't, to my knowledge, I think, enacted this yet, but this could be a model for other kinds of citizen deputizing for all sorts of causes, right? So there is that possibility that goes way beyond abortion itself into lots of other kinds of controversial policy currently.
Right. I was going to mention Governor Newsom because he was proposing how the left could have a field day with all kinds of laws where they would encourage effectively citizen suits that would enforce environmental laws, gun control issues, and the left and the right, I would suspect, is very concerned about the idea of citizens looking to sue each other to enforce laws, personally, no matter what your politics are, we have enough problems with people wanting to sue one another, and creating an incentive where you have this large damage awards, upwards of many thousands of dollars, for activities that would likely not be covered by any kind of insurance policy. And so this could wreak havoc in people's lives if it were a method of law enforcement. Plus, also, it runs counter to, even if you're a libertarian, it runs counter to the idea of what government should do. In other words, government should actually govern and enforce its own laws rather than simply incentivizing people to spy on one another or to have to look over your shoulder to see if someone's going to sue you. So there are a lot of potential philosophical problems that left-wingers, right-wingers, and everybody in between would probably share. In other words, this Texas method of enforcement is, I think, widely interpreted as a clever way of sustaining the law for a temporary time from a challenge in the courts. But once there is an actual suit where you've got a plaintiff and a defendant, the question then will be whether or not the substance of the law itself is deemed constitutional and what degree of state action is involved that can be, assuming the Roe v. Wade standard and the Casey standard still exist, to strike, can be utilized or looked to by the courts to strike down the law, because under a normal enforcement rubric, this law would be easily a violation of the Roe v. Wade standard.
It feels very carceral as well, like a very Michel Foucault kind of way. Everyone, all your neighbors and children are spying on you and reporting you to the thought police. So I guess we've got about 10-15 minutes left. So I do want to say to all of our guests, if any of you have questions, please drop them in the Q&A. We would love to hear from y'all. But in the meantime, I actually want to jump back to something Alison mentioned very briefly earlier, the shadow docket, that the Texas case was allowed to stand, or Texas law was allowed to stand under the shadow docket. I'd never heard that term before. I was reading, articles about this. Maybe, well, I guess since you brought it up, Alison, we'll start with you. And then if you have anything to add, Ian, can you explain what that is and means?
Sure, absolutely. I think this term has gotten really popular lately. It's actually a pretty recent term. I think Will Bowd coined it in maybe a New York Times op-ed. I'm misremembering maybe where, but Will Bowd did coin it within the last 10 years. But it is a really useful term because it essentially it deals with cases that don't actually reach the point of receiving a ruling from the court, but nonetheless have an effect on the lived experience of the law. So for example, in this case, the Texas law could have been essentially halted, stayed from being put into force while it potentially made its way through the system. And the Supreme Court justices opted not to do so. And this was criticized as part of the shadow docket, essentially making law without actually, sometimes it's referred to as showing the work, hearing the two sides and then issuing a ruling. So that's sort of a very basic explanation, but Ian, please jump in and add to that.
As Alison notes, it's a term that was coined in an article, which obviously, if you call something shadowy, it's nefarious, it's evil, and this is a long-standing procedural docket, which one of the slides I showed you where I counted up the pie chart, I referred to them as merits cases. These are cases where the court hears the case, like they are going to do with Dobbs, and they address the legal merits of it. It's not a procedural only decision, but it addresses forthrightly the constitutional claims. And that's what most cases that we think of coming from the court actually address. The shadow docket actually is excuse me, referring to a couple of different procedures that the court engages in regularly where it will deny a petition for review. And the way that a case gets to the court is out of the 9 justices, you have to have 4 justices that vote to hear the case. And it's called a petition for a writ of certiorari, or a writ of cert, as it's called. And the denial of the petition means the court's not going to hear the case. And wherever the case was last heard, whether it was a state Supreme Court or a lower federal appellate court or some other special court, that means whatever happened in that lower court is the end of the case in terms of review by the federal court system. And so the shadow docket is effectively cases that could be reviewed by the merits, but they're not. And sometimes, and all the justices take a vote on it usually, at least as far as we know they do. And as long as there are not 4 justices who support granting cert, meaning granting review of the case, then the case won't be reviewed. So sometimes there have been dissents that have been filed from the decision not to review a case. And sometimes these are publicized and given media coverage. Other times they go under the radar entirely. And these are potentially important cases. There are plenty of cases that come up that might be blockbuster cases, but for whatever reason, the court collectively, there are not 4 justices that want to hear it, much less any more that want to hear it. So denying of cert is one kind of shadow docket case. The other is what are called emergency orders. And these are cases that are pending in lower courts, basically in the federal courts. And these emergencies, sometimes in state courts, but mostly in federal courts, where there's a particular appeal that is sought to be taken at a preliminary early stage in the case, and it is appealed to a particular justice. It used to be back in the late 18th, early 19th century that the justices did what was called riding circuit, where they divided up all of the geographic coverage in the country into different circuits that the justices would literally ride by horseback and by carriage. In fact, it probably shortened the lifespans of a few of these justices because it was tough doing this for months on end. And what they have done is they've restricted, there is no longer any circuit riding, but instead you're responsible as a justice for different circuits in the United States. And that means that issues are brought to that one justice for an emergency order. And sometimes the justice individually will make a decision, but other times there'll be a question about whether or not the order needs to be reviewed by the full court. And justices will sometimes want to be heard on an issue that's been appealed to another judge who's sitting in another circuit, another justice who's covering another circuit. And so the denials or the orders that are issued in those appeals are not always considered by the full court. And they're a matter of judicial economy. They're considered administrative decisions, even though they are substantive legal decisions by a single justice at times. And there have been justices who want them considered by the court because they think it's an important issue that needs to be addressed more broadly. And so I don't think that the shadow docket's as nefarious as it's been suggested it is, even though important issues are sometimes put off potentially to the future or may never come up again. And so it's just a procedural way of, it's a mechanism for handling the overwhelming number of cases that are sought to be appealed to the court. I should note, the court on average, it's right now, this term, it has 63 merits cases, or 63 cases it's going to hear this term. That's actually slightly lower than normal. It's between 70 and 80 cases that they hear on average each term. And that's between 7,000 to 8,000 petitions. So your chances of getting heard by the court when you petition to be reviewed are literally around 1%. And so they've got a lot to look at.
Just to add to that, I do think that shadow has come to have this nefarious meaning, but I don't know if Bowd intended it originally necessarily. And he was a Roberts clerk, so I think he intended it originally to be as like effective in creating law without it being visible as creating law. So, but in the past few years, I'd say the shadow term has taken on that meaning as more and more people have adopted it. So,
well, and I think that, as we run out of time, that kind of brings back to the point that Ian had about people not quite understanding because of the way the news often presents the court and justices and how contentious the past 5 years have been, from Merrick Garland's nomination all the way through, Ketanji Brown Jackson's. But, you brought something up earlier about Justice Roberts being really concerned with public opinion of the court. And this question of abortion and court legitimacy, I think, is a really important one. But so I'd love to hear y'all's thoughts on that. But even beyond that, what does it mean if the public loses faith in the Supreme Court? We don't vote on Supreme Court justices, so does it matter? And if it does matter, why? So just one little question for the end of our program.
Ian, do you want the first word on this one, since I took the first word on the last one?
Okay. I think it matters a great deal whether people have faith in what the court does. The court makes decisions that affect a wide array of citizens, business entities, but also individuals and states as well, lower levels of government. And back in the historical approach to this would be, Alexander Hamilton, back in one of the Federalist Papers, Federalist 78, he said, the Supreme Court's the least dangerous branch to the political liberties or the political rights in the country. And what he meant by that was, and he literally said, it holds neither the sword nor the purse. It doesn't have an army to enforce its decisions, and it doesn't have its own account to fund its decisions. So it relies upon compliance, voluntary compliance by not only the other branches of government, but also the citizenry as a whole. And people like Roberts, who is a good recent living example of this, Roberts is often described as an institutionalist. So even though everybody knows that he's pretty conservative politically, there have been decisions where he's surprised people. The most famous, of course, is the 2012 case it's referred to as the Sebelius case. It's the Obamacare case that upheld the individual mandate. And that was a surprise to those who like and dislike Roberts on the court. And the interpretation, we've never gotten really an explanation from Roberts himself other than the opinion, but the interpretation of why Roberts voted with the so-called four liberals to uphold the law was because he was concerned with whether the court would be seen as taking sides in a very politically contentious issue. And he doesn't want what happened back in the 60s with massive resistance, as it was called, to the Brown versus Board of Education case. And there have been instances where the court has made a ruling and there's been a lot of popular resistance to it. The Brown case is a notable one in civil rights law, but also the school prayer cases back from the 60s. Even before that, famously back in the 1830s, there was the so-called Indian removal cases where the states had the power to take Native American tribes and send them west. And effectively, there were a couple of court decisions that reduced the state power to do this. But the states did it anyway. And so this has always been a fear, is that the court will be disobeyed and effectively neutered if it's not respected. So I think it matters a lot.
Yeah, I absolutely agree. That's a great summary, Ian. I think I would just add that, in the Indian removal cases, there's sort of a famous quip. The ruling in one of those was by Justice John Marshall, who really kind of invented judicial review, the version we have today where the Supreme Court decides what's constitutional or not, was fuzzier in the early Republic, and Marshall really kind of establishes it. And then a couple decades into his term of being Chief Justice, he does make one of this Indian removal rulings in 1832, and Andrew Jackson, probably apocryphally, but still has this reputation of saying, John Marshall made his decision, now let him enforce it. And of course, he could not. Native Americans were sent west in the Trail of Tears not long after, and the sort of sovereignty that the Supreme Court had granted them was absolutely ignored. And Roberts cites that case and refers to that case. And I think, as Ian is indicating, he's right to do so. Brown v. Board is an excellent example of a time when a lot of people objected to that decision. The Warren Court was aware that it would be very controversial, and that's part of why there was a Brown v. Board 2 that indicated that it could only happen with all deliberate speed. And that was to both make that decision unanimous. That was a deal made amongst the justices to ensure that it was unanimous decision, and also gave a little breathing room to states on how quickly they had to enforce it. But you know, the history of its enforcement is incredibly rocky. A lot of states held out for a long time, and successfully. So I think that if the court does lose legitimacy, that it also loses its most significant form of power. And so they should be rightly concerned about it.
Well, thank you. That was a great answer. I've really enjoyed this conversation. Do either of y'all have anything you want to add before we say goodbye this evening? I know it's a hard question.
I do think that I'm not super optimistic that this will be a smooth spring or decision coming out with Dobbs. I think there will be a lot of, no matter which way it goes, there's going to be a lot of people who are very upset and a lot of political fervor around it. So I think being prepared for that and thinking about what kind of activism you personally might want to take part in, both in light of that and just in general in life, is, you know, a good thing to think about now while feelings are still a little calmer than I think they will be soon. So I don't know if that's a profound thought, but one worth having maybe.
Well, Alyssa, I want to thank you for hosting this. I think it's important whenever we can help explain how the court does stuff, and so that people understand how it operates as an institution, because it's, in some ways, it really is. I think this is why the shadow docket was referred to that way as such, because often the court is a shadow institution, not nefarious, but it's just, it's not as visible, and we don't always understand what is going on. And that's in some ways by design. It's not an elected branch. And so these people, they serve for life, and it's 9 people who have this very important pivotal role in understanding and applying American law, you know, in a nation of 330 plus million. And so the more that people like the attendees tonight can understand the court, the better. And so thanks for hosting this.
Well, I'm just
Great point. Thank you for hosting, and thanks to the audience as well.
Yeah, I'm so appreciative of y'all for taking the time to be with us this evening, and you know, both our guest panelists and also our attendees. Thank you. If you are local, we are going to be back on site for our next program on April 9th. We'll be doing it hybrid, so if you're not local, don't worry, you'll still be able to watch and ask questions. We have Kyla Schuller from Rutgers University talking about her book, The Trouble with White Women, A Counter History of Feminism, which talks about all the different threads through American feminism and the different movements and forms of activism that were happening alongside the kind of more well-known ones we have. And it should be fantastic, and get her to sign your copy of the book. And if you enjoyed this program, please hop over to our website and consider donating to us so we can continue to bring these to you for free. And have a wonderful evening. Enjoy this new warmer weather and the longer daylight.